Thank you. Appreciate it, Chuck.
Okay, you're on.
Oh, I don't get one?
Would you like one?
Yeah, I would.
Here's one.
Thank you so much. Okay, good morning.
Good morning.
Do I need this up higher?
Nope, you sound great.
Sound great? Okay. Terrific. Wow, I'm not used to having all this stuff here to assist me. Well, my name's Neil Kalin. I'm one of the attorneys at CAR. I'm Assistant General Counsel at CAR. I've been there a long time, over 20 years now. A couple of things that I do. I'm the Senior Legal Advisor to our Standard Forms Committee, so I have something to say about all 150 or so forms that CAR has. I occasionally answer the CAR legal hotline. I come out and do a lot of speaking engagements like this. I teach classes for CAR for Realtor Continuing Education Credit. And I write almost all of the briefs that CAR writes when we find a case that is of interest to real estate agents statewide. We will submit a brief to either a court of appeal or a Supreme Court trying to get your view across to the court, so hopefully they can tailor their opinion in some way that will either help you or not hurt you so much when the decision is finally decided. So today, what am I going to talk about? Talk about some new laws, some new cases, talk about some of the new forms, and why don't we get right into it, because I guess you guys have other things to do this morning, like go out and see some properties and hopefully make some money. So I'm going to get right into this stuff. Let's take a look at the new laws. Well, what's the first one up there? Talks about short sales and deficiencies. Of course, a lot of what I'm talking about this morning is going to deal with distressed property market because that's affecting so much of our state. So what is this new law? By the way, all the laws I'm talking about take effect January 1st of next year unless I tell you something different, okay? So this law, good law, will help some people, will make, I think, some people feel more comfortable in the short sale process. And what it says is, again, starting January 1st, if a lender has agreed to a short sale and the loan is secured by a first trust deed only on residential 1 to 4 property, that lender cannot pursue the borrower following the short sale for a deficiency. The difference between what the property sold for and the amount that the borrower actually owed on the loan. So let's try and put that in context. Currently, under California law, even before this law, if a property goes to foreclosure, there's 2 types of foreclosures that can happen in California. Judicial foreclosure, non-judicial foreclosure. Almost everything in California goes to non-judicial foreclosure, a trustee sale. Following a trustee sale, I don't care what kind of loan it is, I don't care what kind of property it is, following the trustee sale, if there was a deficiency, the lender cannot pursue the borrower for that deficiency. Now, if by some chance the lender decided to pursue a judicial foreclosure, which is a lawsuit to foreclose, the lender can still not get a deficiency against that borrower, can still not pursue the borrower for that difference, if the loan was what's called a purchase money loan. The loan was used to acquire residential 1 to 4 owner-occupied property. The trouble is short sales are not foreclosures. They're not judicial foreclosures or trustee sales. And so in a short sale, a lender has the legal right to go after the borrower for the differential. And what we've experienced is some lenders are pretty upfront about this in their short sale consent letter or their term sheet. Some lenders will say, borrower, we're going to waive the difference. We're not going to go after you. Some lenders will explicitly say, borrower, you still owe us all or part of that differential. We like those lenders because we know what they're doing. Some lenders put into their term sheet something that says, we reserve our rights. Which means what? It means whatever they think it means is what it means. Okay? But it probably means if state law allows them to pursue the borrower, they can. Now, most lenders don't do this on their own. They'll sell their note in the 3rd to to a third party in the marketplace, usually a collection agency or a law firm, that buys these up in bulk at a huge discount and figures if they can collect on some of them, they come out ahead. Okay? But starting January 1st, if the loan is secured only by a first trust deed, residential 1 to 4 property, the lender will not be able to sell that because no one will buy it because the lender cannot collect that differential. Now, what about a second lien holder? Law does not apply, they can go after the borrower. Okay? There's another exception to this law. This law does not apply to a borrower who is a corporation. So it's really there to help individual borrowers. Okay? So somebody took title in the name of their corporate entity, their LLC, too bad. They're not going to be able to rely on this law, and the lender might be able to pursue them under the law. So that's our first new law, short sales and deficiencies. What's our next one? Notice to tenant after foreclosure and before eviction. Okay. So again, a little history here. What's the law right now? The law right now says, basically, if we have a rental property that's going through foreclosure, at the time the lender files the notice of sale, right? So what's the whole foreclosure process? There's a notice of default, then there's a notice of sale. At the time the lender files the notice of sale, the lender has to send out a notice to the occupant, address dear occupant. And the notice basically says, your property is about to be lost in foreclosure. The property you're renting is about to be lost in foreclosure. And that notice gets sent out in 6 languages. Okay? Because we want to make sure that at least most people will get it, will understand it. So if you can read Spanish, Chinese, Korean, Tagalog, or Vietnamese, oh, and if you could read English, okay, then you're going to get this notice that says, hey, basically in about 30 days, this property is going to be sold at a foreclosure sale. Okay? If you bother opening up mail, it's addressed to occupant. All right. So then you actually have the foreclosure sale. Most residential tenancies are what are called junior interests in the property. And so the actual foreclosure sale terminates the tenancy. Okay? And currently in state law, after somebody acquires title, the bank or a purchaser, the REO, under state law, they have to give that tenant 60 days notice before the tenant has to move out. Under federal law now, that notice is basically 90 days for a month-to-month tenant. And a fixed-term tenant may not have to move out at all during the term of the fixed-term lease, residential tenant. So what did California do to add to all of this, to add to all these rights? They adopted this new law taking effect January 1st that says, within the first year after the foreclosure sale, this REO has to add this cover sheet to their notice, their 60-day notice or their 90-day notice or whatever kind of notice they're giving, that tells the tenant a variety of things. It tells the tenant, hey, guess what? The property's been sold at a foreclosure sale, in case you didn't read that notice in any of those 6 languages before. Okay? You may not have to move out for 90 days. Okay? If there's been a lawsuit filed, you better respond. You probably should talk to a lawyer. And if you can't afford a lawyer, guess what? Here's a website where you can find a lawyer that'll talk to you and advise you for free. And that cover sheet has to be attached to the termination notice. So to make sure tenants are advised of their rights. And again, that starts January 1st. Let's look at our next one. Foreclosure property maintenance. You know, let me take some questions at the end because we've got so much to get through. I want to try and get through as much as I can. Foreclosure property maintenance, what's the current law? The current law is a city or a county, a local government entity. In order to avoid blight, they can charge an REO that has vacant property up to $1,000 a day for some kind of nuisance or violation. Well, needless to say, banks weren't too crazy about that law. So they went to the state and said, you know, give us a little bit of help here, and the state did help out, starting January 1st. And the state says, well, wait a minute, before a local government entity can assess a fee or can even lien the property to what's called abate the nuisance, to take care of the problem, well, they've got to give notice and an opportunity to cure to the REO, which certainly makes sense. Okay? Furthermore, the new law says any kind of lien or assessment, oh, I'm sorry, you're feeling I'm moving around here. Any kind of lien or assessment, the charge has to be reasonably related to the actual cost. Just can't make up $1,000 a day because you didn't mow your lawn. Okay. And furthermore, there's one other thing, starting January 1st. Before the local government entity can even charge or place a lien, they have to have an approved list of fees that have been approved at an open hearing, okay, an open government meeting. Now, they don't have to do that for each individual property. In other words, the city or the county could set a schedule. Failure to mow the lawn is X. Failure to maintain the pool is Y, etc., etc. They have to do those things before they can charge. I like this next one, Section 1D, renting out property without owner's consent. Assembly Bill 1800. Okay, so what does it say? You cannot rent out somebody's property without their consent. Now, I kind of thought that that was illegal already before January 1st. And the fact of the matter is, it is illegal already. Okay? What's happening January 1st is the fee or the penalty for doing so is being increased more than doubled. It's going to be a $2,500 penalty to do so. Plus, the other penalty is up to 1 year in prison.
Good.
And the law applies to two different things. It applies if, for example, me, if I go out and I rent somebody's property, right? This has happened a lot with the distressed properties. The owner moves out, or it's a REO property, nobody's there, somebody moves in, says, hey, I know, I'll put an ads on Craigslist. A tenant will come, I'll say, look at this beautiful place. Okay? Rent it out, I'll take the money and I'll run. Right? So that's a violation, $2,500 fine, up to a year in prison. It's also a violation if I cause somebody else to do that. So I'm not going to go into the property itself. I don't want to dirty my hands. But I'll put the ad, or I'll contact a realtor. I'll say, hey, why don't you rent out this property for me? Maybe I'll even sign a lease listing with you. Okay? So I have caused somebody else to lease out property that I do not own. And that is also a violation of the law. But because we see so much of this going on, and hopefully you don't have that much of it in your community, but if you do, it goes to the point of you're taking a listing now, you certainly want to have a property profile, you take a lease listing, you want to do the same thing. Is the person who's contacting you actually the owner? You check that out so you are not assisting them in violating this law. Next topic, foreclosure consultants. What's a foreclosure consultant? Foreclosure consultant is basically anybody who promises to help a homeowner in foreclosure get out of foreclosure, avoid the foreclosure, postpone the foreclosure, etc. And under current law, if you do any of those things, you cannot collect an advance fee for those services, and you have to register with the State Department of Justice, because we want to know who you are and where you are. So what happened? You had all the people who were doing subprime loans, that dried up, so they went into foreclosure consultant activity. Oh, now they can't get advance fees and they have to register with the Department of Justice. Said, oh, you know what? There's something else we could do. we're not going to help you, homeowner, get out of foreclosure or postpone your foreclosure, but what we'll do is